So for item number 15 here. One. Ahead. Did not.
1-5.
Yes.
Okay. They did not receive list again on
25. Right? 21 then.
Master place.
Regarding item 14, Lordship, the TCR has come scan copy of TCR, but it's not tagged with the file, Lordship. I will be permitted to call for the scan copy of this. From the king.
will it be possible?
If he can go through it, Lordship, he will take some time at 2 p.m.
No, TCR may have arrived, but there is a lot of processing to be done before sending it to the court.
Court allows, will send,
You can take a chance.
Lordship.
If it doesn't come, then tomorrow.
Lordship. It is a, we have got the information.
Anyway, we are raising early today because of the reference.
Let's see, Lordship, next date it will be easier, Lordship, if we take.
Oh, so rather let us say, fix it for tomorrow along with LCR.
Try today.
Easier that way.
Happen, Lordship, otherwise.
Why go for ifs and buts? You are not there tomorrow.
Yeah, Lord.
Then what is such a difficulty? What is the offense?
Easier to.
Then they want.
Charge sheet is there, Lordship. Trial is yet to be started, Lordship. Only charge sheet will be there.
Okay, tomorrow. We'll give it for tomorrow. Change the date.
Much obliged.
Mayor, please, Lord.
14 list tomorrow with TCR.
Mayor, my Lord, I said to mention item 40, my Lord.
40.
40, my Lord.
Yes.
It has come in hearing column, my Lord.
Mhm.
I want to, there is some urgency, my Lord. Kindly be taken at 2 today, my Lord.
We'll take it at 12 if you like. If it is so urgent. Wait for your turn. Let it come. Yes.
Possibly, it will not reset.
Are you sure?
My Lord, on 3:15.
Okay,
Okay.
at
Times and again, this matter has.
okay, at 2. Okay,
but,
at 2.
not.
Adam?
I-
Subject to the condition that if the list is over by 1, then we'll not sit at 2. Will not take up your item before 2.
Then, my Lord,
And if the list is over before 2, then we'll not sit at 2.
my Lord, then after admission, my Lord.
That is why I say just wait. You can make a mention at 1 also if necessary. Yes.
It's better for listing as application by your appropriate way to
Tomorrow.
With the Lordship, I would like to mention item number 30. Lordship, CD has not been yet. Lordship,
All right. Did
matter
not
may be
receive
adjourned.
list again on?
Interim.
Interim order passed earlier to continue till next date of listing. Give the date.
27/11.
Item
Hmm.
Item
Speak a
number
little
21.
louder.
Item number 21 Lord,
Yes.
has been issued.
Hmm.
Pay for on
Item
21
21 on
or
the
20.
prayer of TCR is received on the prayer of learned counsel for the
Yeah.
petitioner. Is the matter again on?
24 Lordship. 20.
All right.
Highly obliged.
Idea. Order is B30. Regular bail already both are actually infected comes under the Sexual Harassment Act. But the allegation is that your loss already observed my page 30. I have come only for the length of the day. For that moment. 48 days. Both are employed in the same office.
What is the length now?
48 days. I think with the statement, everything accorded, madam, as per your lordship. That observation, that all. I think nothing more is required for the customer. Idea came your lordship on 10/20.
Territory is 60 days.
Is it 90 days?
Hmm?
And
90.
if my lord, your lordship, our irrigation is for last 1 month, my lord, I was harassing her. Not a single complaint made to that, my lord. SP Act is there, my lord. For that purpose, my lord. They have registered under BNS.
Yes, PP, what do you say?
Lordship, earlier order
Sure.
reflected.
Yes, material is there.
Yes, sir.
Material is there, so we don't need to call for the CD. We have already
Only thing is that
reflected. He is only on length of detention.
My lord, I am not on.
Only thing is that whether city is submitted in the meantime or.
Not yet. I on oath. Not yet, sir. Yesterday we.
It will be the same.
Already heard, Mr. Senior Counsel. And additional PP. Page number 32. First para. Third para also same. This court by order dated 23/10/25 had rejected a previous bail application being bail application number 3264 of 25. After perusal of the CD. Para Learned Senior Counsel submits that considering the length of detention of 48 days, the fact that the statement of the victim has already been recorded, the statement of the victim as well as that of other independent witnesses already been further detention of may not be has also been pointed out by Learned Senior Counsel. Despite the allegation of sexual harassment continuing for a long period, not a single complaint was filed by the victim. Also, there are be that may having regard to the period of detention. The prayer for bail is 50,000 to security conditions and try to intimidate the witness.
PM Kachar
Decision.
obliged.
The suspect case.
May I please your honor? Lordship, it is a suscited case, Lordship. Lordship, kindly come to page number 23 of the of my bail application. May I read out the facts disclosed during investigation, Lordship? The second paragraph is important, Lordship. During investigation from the statement of the victim, it is revealed that on 19/8/2025, at morning, victim namely Mariam Nessa, 15 years, 5 months, daughter of so and so went to her school, namely Jatiya Vidyapith, situated at NC Bandia. During lunchtime of that day at about 11 a.m., accused, namely Hussein Ali, son of so and so Bandia, along with other accused person, Saddam Ali, Yaqub Ali, and Fazal Ali, induces the minor girl and kidnap her from in front of her school, which is situated at NC Bandia with Marjikar. Hussain Ali gave the minor girl to drink water. As a result, that she became senseless. When she woke up, she was at Ghagrajuli at the house of Hussain Ali's sister. And both Hussain Ali and the victim girl passed the night at the same place. The victim girl stated that the accused person did not sexually assault her. On the next day, the father of the accused person, Hussain Ali, brought back both of them to the Bandia village. Very next day, the victim girl recovered. And the conduct of the petitioner and his family members is very good, Your Lordship. Lordship, and the victim girl specifically stated the accused person did not sexually assault her. And finally come to my page number 22 of my bail application, Lordship. Lordship, at column number 14, Lordship. Result of laboratory analysis, expert opinion, medical examination. There is no sexual assault took place, only routine checkup done. So far, the section 96 is concerned, Lordship. The purpose of the section 96 is sexual intercourse, Lordship. And that was not done by the petitioner, Lordship. The victim has stated, Lordship, in her statement, Lordship. The
What
purpose
is your date of arrest?
of her Lordship, charge sheet has been filed and charge has already been framed. I pleaded not guilty, Lordship.
Date of arrest.
Date of arrest is 24 August 2025, Lordship. It is 79 days, Lordship. And
Third
the
learned
receipt
counsel,
is
the
all
petitioner
the
decision
of the
application under so and so. Under section,
will cooperate with the trial, Lordship.
allegation against petitioner as affected. The FIR is that the petitioner kidnapped the niece of the informant who was aged 15 years, 5 months. During her leisure period at school. The case has already been charge sheeted and charges have been framed where the it is pleaded not guilty. It appears that the victim was recovered the very next day, and it is reflected in the charge sheet that the victim girl stated that the accused did not sexually assault her, which is also supported by the result of the medical examination, which is also reflected in the charge sheet. And in the meantime, the petitioner has spent how many days?
79 days, Lordship.
79 days behind bars. Having regard to the above facts and circumstances, the prayer for bail is about 50,000 considered.
Deeply obliged, Lordship.
Will regularly appear before the trial court condition.
Your Lord. On the page 80, there, FIR, Your Lord. Whatever, my Lord, the petitioner belongs to Jehapari, my Lord. And on that day, my Lord, he also went to the ATM, my Lord, to take out money. The person was inside, my Lord, was taking a long time, my Lord, to take out money, my Lord. There was an altercation, my Lord, and he has lost the false. From forwarding report, it revealed that, my Lord, there was an attempt to take money, my Lord, from him, but there not even a single penny was taken.
CD will
Lordship,
appreciate.
may kindly see the forwarding report, my Lord. Yes, sir. Paragraph 14, page 14, my Lord. The attempted, my Lord. Take 2020. Not a penny was taken, my Lord. Actually, there was a verbal altercation, my Lord.
Because you were stopped. That is
Normally,
why.
normally, he was, when I belong to Rehabari, my Lord.
Anyway, this is not a case for first that
Lordship, a call for the case.
21/11.
Oblige, your Lord. The allegation is regarding, my Lord, theft of a mobile, my Lord. But I have not stolen that mobile, my Lord. From the forwarding report is revealed, my Lord, that another boy, my Lord, He has given the mobile to me, my lord.
These are all interoperational.
CG Lordship. 20 or 11 Lordship.
Oblige, your lordship.
Lordship, as alleged in the FIR that have carried a big gold medal. That is also on the suspicion ground I have been arrested. Lordship, kindly come to page number 16, your application. Kindly on the paragraph number 2 here. Here it is written that in course of checking at around 4:30 p.m., we intercepted a person at PF number Kamakya station. Finding him suspicious, we checked his backpack, during which we found one half-boat shaped yellow color metal suspected to be fake gold inside his yellow backpack. Lordship, in this case, I have a special request, Your Lordship, that the petitioner's son's marriage is scheduled on 19. That is why I made an interim prayer, Your Lordship. Any stringent conditions, I'm ready to comply, Your Lordship.
Equal weighing measurement of 868 grams.
I am trying to make out where the offense has been made
Yes.
out. That way, a lot of ladies will have to be arrested.
Lordship. Wearing.
Yes. Had learned counsel for the petitioner and learned additional KP. The allegation against this is an application and the allegation against the petitioner as reflected in the FIR that he was found in possession of fake gold metal weighing 868 grams, and accordingly he was arrested on suspicion of being a member of a fake gold racket and that he was carrying the same in order to dupe innocent people by presenting the same as pure gold. So a bare perusal of the FIR would show that no actual act as apprehended by the arresting authority has been committed by the petitioner. Possession of the metal, whether real or fake gold by itself, is not an offense in the absence of other materials. The petitioner was arrested on
111.
1/11 and has therefore spent 11 days in custody. By now, his interrogation would also be over. In view of the aforesaid, the prayer for bail is allowed. Petitioner so and so shall be released on bail of is 50,000 with 2 serious like amount. That is which learned magistrate connection with the aforesaid case. Petition stands allowed.
Obliged.
43.
May I please, Lord? My lord, this is regular bail. I am in the first days. FIR is at page number 10, my lord.
Yes, what did you do?
Allegation is stealing away from storeroom. Page number 13, 11.
For
On-
theft, CB?
Lordship. It's from Orpeta. 20. 24/11.
Highly obliged.
Item 5.
Get your loss. The listed idea, my lord, now we find that, my lord, on the list after, we are under the impression the CD was called for.
It was called for, we have received.
Receive.
After some time,
My lord, it is business rivalry, my lord, both the parties. The market allegation is attempt to murder, my lord. Market itself, my lord. Nothing happened, my lord, to our information subject to your lordship, they may say, my.
So
It-
although this case has been shown in the motion column, my lord, but earlier, my lord, case diary was called
Yeah.
for, my lord. But it is why, my lord, we are producing the case diary in the motion.
All right, if you have the case there, you
Yes.
see.
Otherwise, my lord, in motion itself, my lord, we normally do not put.
No, that was actually, in fact, CD was called. Yes.
Okay, let's not quibble over that. We need to get over the case. It's there, let's see.
Now only let us see whether, my lord, that any injury is there or not, whether that much. Amount. Nothing happened, my lord. Self-inflicted. The midst of the market.
Injury report is also there.
The report is there.
There. What does it say?
The report, my lord, is simple caused by blunt objection. Eyewitness is implicated, my lord. This person, they have assaulted.
No, business, that we admit, my lord, altercation took place, nothing more. Business rival.
There are 3 accused.
Take this person, my lord. Abdul Basit and Tabara Kali, my lord, they caught hold of the, my lord, victim, my lord.
Hmm.
And Abdul Sadiq, he assaulted.
Assaulted with what?
My lord, allegation is they assaulted with dao, my lord.
What is the nature of the injury? Otherwise, where is the injury caused?
Yes, my lord. Injury caused, my lord. Forehead, my lord. And the second injury in the, my lord, back of chest. Starting from shoulder up to feet of artery bump.
But they're simple.
Yes, as per the injury report, my lord, injury caused by blunt object and simple in nature.
So it must be the reverse side of the dao. If it is
Exactly, my
blunt
lord,
object.
That is not clear. So,
So one hand they say dao and blunt. The assumption is that hard, Mr. Counsel. Burwal, this application. But there is not even an order call for the CD. It only says list it on 11/11/25.
That's why I stated idea, my lord.
That is why it's in the motion column.
But in fact, CD was called, my lord.
I don't know.
in our, my lord, in our petition also, my lord, case that an injury report called from, my lord.
In my petition also,
Anyway.
it is there. my lord.
The case diary along with injury report is available. The allegation against the petitioners. Paragraph 4. A perusal of the injury report, however, reveals only simple injuries caused by blunt objects. False. Para having regard to the above, the custodial interrogation of not be necessary. Accordingly, the prayer for pre-arrest bail is allowed. 50,000 security each. Jonas,
That there be some strict condition, my lord, they are not fit in the, my lord,
order provided by
problem.
petitioners shall cooperate with the patient. Appear before the IO then when called for. Further shall not try to influence or intimidate the is in any manner. Or for the investigation or tamper with evidence. Accordingly. Pranjal Das. He's in, I think, he's in Arunachal.
Need pleasure. Is a petition under 483 on 16/7/2025, page 10, Lodge. A FIR was lodged alleging an offense committed of a dacoity in a truck containing 399 cartons of pan masala. Now the truck has been recovered. The cartoons, 95% has been recovered. 373 cartoons have been recovered as on 31/7/2025. Now my name, all persons involved in this crime has been arrested. Now my name nowhere appears. One of the, what has been told that some of them are drivers of the same company. I am also a driver of the same company. One of the arrested person was using my SIM card in my name. Therefore, police has visited my home for some interrogation. I am ready to cooperate, Lordship. Otherwise, Lordship would see at page 21, out of 399, only 26 cartoons are left to be recovered. And the truck is also recovered in a good condition and no harm caused to the driver also.
So those 26 are with you.
No, Lordship, they wanted me to ask why my SIM card was, because all are non-bailable offenses, I am apprehending arrest, Lordship. I am ready to cooperate otherwise. Any conditions?
CD may be called for.
So we need the CD to see your role. How can we say that your custodial interrogation is not necessary at this stage? Call for the CD.
24/11/25.
Sir, the bail application filed against the non-bail warrant against number 1. The woman lodged an FIR on 17/1 alleging that her minor daughter was missing. Subsequently, the victim was found. After attaining the majority, they have they solemnized the marriage. I have annexed the photograph.
But what is the reason for your non-appearance?
My lord, we do the petition of one that he is from Kolkata. Does not know the proceedings pending before court, nor it was informed by the family of the victim. That is why I placed the form.
Where have you stated that?
Paragraph 8. The victim has been married by the petitioner on
It is submitted and showing as a
Trustee
second.
submitted, my lord. Trial is before the trial, going on trial.
Had learned counsel for the petitioner.
It submitted on 31/5.
This is application. Under so and so. Filed by the petitioner. As a NBWA has been issued against him after charge sheet had been filed in the case showing him as an absconder. Where it is submitted that the petitioners showing them approval.
Only petition number 1.
One.
Petition number 2 is the wife, my lord, the victim.
Cooler. Then how many petitioners in this?
Two
Two are
petitioners, my lord. Victim is the wife, my lord.
no. Why is she a petitioner? Has NBWA been issued against her also?
No, my lord.
Then
Just
why
to
is she a
prove before this
petitioner?
honorable court that she was with the petitioner number. After solemnizing marriage. That's
Paragraph 11. It is further submitted that the petition number 1 against whom NPWA has not aware of the passing of the orders by the learned trial court at Majuli as they were residing in West Bengal. Para having figured hope is provided that the petitioner number 1 shall appear before the learned trial court and file appropriate application for bail, which shall be considered by the learned trial court as per law. In the meantime, the NBWA issued against the petition shall be kept in abeyance. It is hence disposed of accordingly within a period of 15 days.
Obliged.
Yes,
Lordship, FIR that page 16, Lordship. 11 pages 16. Lordship, I am tax collector of the Gaon Panchayat. Lordship. So allegation is that some villagers had alleged, gave some video clip that I had demanded money during the survey of the Awas Class 24 scheme, Lordship. And thereafter, it was preliminary inquiry was made by the person and the FIR log. Lordship, the report is at 19 and 20, Lordship. Lordship, I'd like to draw your honor's kind attention to page number 20.
yes,
First paragraph and second paragraph, Lordship. First paragraph, Lordship, allegation is that he offered me this amount, 200, and I misbehaved. He did not pay me, Lordship. The second paragraph is only the HCL number 7 witnesses. 7 witnesses were examined by them, Lordship. Only these 2, the 7 said that he paid me 500 rupees. Lordship, I am a tax collector in Gaon Panchayat, Lordship. All the allegations are false and baseless, Lordship. Even if, Lordship, on face value, even if the inquiry report, this evidence is accepted, Lordship, then also, Lordship, the alleged offences never come out, Lordship. All the offences, P18, P082, P116, and 61 to Lordship. These offences never attached, Lordship. And all these offences are also less than 7 years punishment, Lordship. The police has not given me notice under section 41 of the CRPC, Lordship. And there is no requirement of this custodial detention, Lordship. The police has also not followed the Ernest Kumar, Lordship, the guidelines. And I am a local person, Lordship. I have stand trial. I had faced trial, Lordship, and there is nothing to hamper the investigation, Lordship. And my custodial detention, my understanding, Lordship. My
anyway, we have to see the CD first
Lordship, interim, I may be protected.
because it was
Mr. President, the
rejected
case
after perusal of CD earlier.
Lordship, this,
We don't
this
know
much
what
is
is
in
there.
there will not be much more in the CD, Lordship, because the so far as this report is concerned, it is an inquiry report by them, Lordship.
No,
I may be protected, Lordship.
what they have
during
stated,
pendency.
we do not know. Had there not been a previous rejection after perusal of the CD, normally we do, but it is the practice of this court at least. If it is
24/11.
rejected after perusal of CD, we have to see the CD.
Obliged.
Well, this 20 application, kindly I
CD.
My lord, she is my wife, my lord. May kindly see, page 15 is the marriage certificate. My lord,
Then-
some dispute arose, my lord.
Has she come? Then how is
My lord,
categorically stated she is not married?
my lord, para section 7, my lord, I stated, my lord. What is the actual fact? She stay with me, my lord, few days. Thereafter, my lord, left me, my lord.
Even if it is your wife, there is a allegation that you circulated her videos.
Yes.
My lord, the allegation section is, my lord, it's my lord, not there, my lord. Section is, my lord, 69 of BNS. Okay.
Well, have the CD.
CD Lordship,
My lord, meantime, my lord.
from Borpata, 2611.
At the facing Lalit. Exit number 6. The second upon
Some other day. The spirit for by council is the matter again on.
it
You
is
could-
going and if
Hmm?
and
All right, 8th of January.
there's an interim order.
What is the interim order about?
There's an interim order of stay of the
All right, January.
Lordship,
Publish.
I am appearing for the respondent in.
Hmm.
My senior will appear in this. Today, the case was fixed for the final disposal. So, my lord may take up the matter. Time. They have filed one affidavit also on the last. one.
There is no such order that is for final hearing. Simply list the matter for admission hearing.
My lord may take up the matter. My seniors,
Lordship, have it sometime. the
All
time
right, after some time.
I'm deeply obliged.
Is the fix for my lord regarding maintainability. If the aspects of the case is that against the husband, but because of the non-payment, my lord, the Lanet Court Bureau has issued state warrant of arrest. And my lord, in the DB Act, my lord, 29 section is there, out of which appeal is also provided. But instead of that appeal, my lord, we have filed this revision petition. Now, the other side raised the issue that in the present premises, the revision petition is not maintainable, and therefore, my lord, that today is the date fixed for hearing on this issue of the revision petition. My lordship, it is indeed, my lord, that section 29 provide for appeal, my lord. But it is also open that, my, in case of miscarriage of justice or the law has not been rightly applied, my lord, by the trial court, my lord. In that case, my lord, revision petition maintainable. On that issue, my lord, I would like to address my submission. My lordship, kindly see for a moment the order passed by the trial court below page 70. On law point, my lord, I have filed this report. Leaving aside all the merits of the case. Page 72, lordship, middle line. Distressed warrant of arrest issued, returned, unexecuted issue afresh, agreed to take step, failure warrant to issue after due. Now, lordship, so far this, my lord, non-payment of dues are concerned, my lord. This procedure cannot be followed, my lord. Under section 31 of the DB Act, my lord, in case of non-payment, my lord, a separate proceeding has to be thrown up. It is not a section 125 proceeding. Second point is that, my lord, under section 70 of CRPC or, my lord, warrant of arrest can be issued, and under section 421, my lord, warrant of attachment for property can be issued, my lord. But both cannot be issued together, my lord. Therefore, only law point is that, my lord, distress warrant of arrest is not provided under CRPC alone. Second point is that, my lord, law point is that in case of default, my lord, then the procedure is that section 31 has to be invoked. Now, only these two law point, my lord, I have filed this revision petition. I'm not going to, my lord, touch any of the merit of the case for more. And for that purpose, lordship, just to satisfy this honorable court whether this power can be exercised or not.
No, firstly, you say that which part of the order is wrong? Mm.
My lord, kindly see it's like page 74.
Yes, 74,
Yes. Sorry, my lord, page 72.
yes,
My lord, middle line distress point of arrest.
yes.
It is not provided in the CRPC. CRPC has provided two parts, section 70, arrest of warrant, and section 421 provide attachment of property. And both are different from each other. Second point is that, my lord, in case of default of dues amount, the DB Act provided the particular situation.
What is the section under which distress warrant is issued?
But distress warrant of issued can be, my lord, warrant of arrest, there is no procedure, my lord. There is no such provision on the CRPC. Both are different from each other, my lord. Either it has to be issued arrest warrant under section invoking section.
If they are different from each other, then both have to exist at some place.
My lord, if suppose arrest of warrant is required, my lord, then it has to invoke section.
Under
70.
what provision of law distress warrant is issued? That is
Even
the
when
question.
in-
You say there is no such provision.
My lord,
So all the courts have been issuing distress warrants without any
my kindly
authority
see,
of
my
law.
lord, both are to be followed by different form, my lord. Arrest of warrant followed by
Which show
different-
us.
Yes, my lord. So far, my lord, section 421 relates with the attachment for property. Form 43 is applicable.
Section?
Section 421 CRP.
Hmm.
In case of issuance of attachment for property, the form is applicable, form 43. And in case of, my lord, issuance of warrant of arrest under section 70, the form 2 is applicable. Now,
Form 2.
yes, both cannot be clubbed together. It has to be issued separately, ma'am. And both section can be invited once, my lord, the separate forms are there.
Where is that form? Where is
My lord,
it?
that is the part of CRP.
No, no, what has been issued in this case?
Nothing, my lord.
What do you mean
Just one.
nothing? Then
This is just an order, nothing more.
so your case is that instead of saying DWA, it should have been said
Yes, attachment property is normally, my lord,
attachment.
normally followed, my lord. In case of, my lord, recovery, then attachment.
Your problem is only with the nomenclature.
Nomenclature,
Is it?
suppose in case of default, my lord, recovery is necessary, my lord. In case of recovery, my lord, the property has to be sold out and for that purpose attachment required, number one. And sometimes, my lord, if we see for a moment, my lord, in case of section 125 CRP, non-payment, my lord, sometimes even also arrest of warrant is issued. It is the discretion of the court which part the court inclined to, my lord, invite. And other than, my lord, kindly see that section 125 and so far section 20 of domestic violence are different, my lord. In case of non-compliance of the order passed by the trial court, my lord, in case of, my lord, section 23, proceed, just look for a moment, section 31 of domestic violence. Separate procedure there, my lord.
Section 31 of
Yes, my lord, Domestic Violence Act, Protection of Women from Domestic Violence Act 2000.
yes, what does it say?
My lord, says, section 31, penalty for breach of protection order by the respondent. Any order passed, my lord, a breach of protection order or of interim protection order by the respondent shall be an offence under this act and shall be punishable with imprisonment of either distinction for a term may extend to 1 year or with fine which may extend to 20,000 rupees with both. And part 2, the offence under section subsection 1 shall be so far practical be tried by the magistrate who has passed the order.
So in this case, the order was one of protection.
Protection, my lord. The protection
But-
earlier it was issued that contained in, my lord.
Where is that order?
Yes,
In
ma'am.
respect of which this proceeding is going on?
Yes, my lord. That order contained first order, my first order is order is not there, ma'am.
It is only for the interim payment, not protect.
Then 31 is irrelevant.
My lord, because my lord, the interim protection granted by virtue of inviting section 23. Because that is only the procedure out
You
of,
cannot even show us that order.
yes. That order right now, my lord, I don't have, if proceed permits me, I will apply for certified copy, my lord, and place it, proceed by affidavit.
You have the order.
Just now
Undisputed, my lord, there is a direction.
my lord, even though my lord, whatever may be, was that it dated. But case, first of all, under section 29, the ability provided. And all these points he could have raised in that particular appeal, my lord. Secondly, my lord, your lordship will come. The order, last order dated 72.
I would like to place for citation if permit.
Yes, yes, you can do that.
72, my lord.
Let's just get over the facts first.
72, my lord. And this is the offshoot of the order dated 18. 18/6/2024, my lord. I'm giving the copy.
And the part of order contained in my lord, page, paragraph 5, page 4, my pit.
This order has been, is the offshoot of the order dated, because he has not complied. This one. Issue DWA against the respondent number 8. Since he has not challenged this particular order, my lord, there is no scope at all for my brother to challenge the order dated 27.
Yes.
Now, my lord, I am taking to your notice to Rule 12 of the Domestic Violence Rules and sub-rule 6, my lord, thereof. Sorry, my lord. Rule 6, my lord, not 12, 6, my lord, and sub-rule 5 thereof.
Rule
Rule 6,
Rule 6.
yes, sub-rule 5.
Yes.
The applications under section 12 shall be dealt with, and the orders enforced in the same manner laid down under section 125 of the Code of Criminal Procedure 1970. Now, my lord, I am taking to your lordship to section 125 3
Of
the act.
yes.
Subsection 3, my lord. If any person so ordered fails without sufficient force to comply with the order, any such magistrate may, for
every of the order issue a warrant for levying the amount due in the manner provided for levying fines and may sentence such person for the whole or any part of it on allowance, maintenance, interim maintenance, and expression of proceeding, as the case may be, remaining unpaid after the warrant to him. So, my lord, the procedure which has to be followed, that is for recovery fine. Jackson. Now,
So according to you, that is the provision under which the magistrate has passed a order.
for realization of the fine, my lord, according to section 421 and 431 of the CRT.
Yes.
So that being the position, my lord, first of all, the petition is not maintainable. Under section 29, he could have raised all those points in there.
Yes. Pass over the decisions what wanted.
My alternative prayer, my lordship, my alternative. Lordship feel that my revision petition is not maintained properly. So I cannot be remedial. The opportunity be given to my approach before the competent. That observation.
Were we to give the opportunity?
Yes, ma'am.
Law will give the opportunity if it will give.
Yes, ma'am.
If the law provides you with an opportunity, with a remedy, you will avail of it.
Absolutely, my lord, because that my lord, time we have, my lord, passed.
There is nothing for us to say.
Limitation is there, my lord. That's why, my lord.
We can't change the limitation.
Absolutely, my lord. Lordship may place two citation, my lord, in support of my, my lord. Yes. This is first citations 2012-9 SCC 460. Relevant part contained in paragraph 8. I have earmarked line. I'm playing up. Still part. The line start from image that. That image that the revisional fiction can be invoked where the decision under the challenge are grossly erroneous. There is no compliance with the provision of the findings recorded is based on no evidence, material evidence, exercised arbitrarily or purposely. They are not exhaustive classes but are merely indicative case determined on its own merit. Now, my lord, another paragraph I would like to read upon, that is paragraph 12, my lord, page 14. Paragraph.
Yes.
Now, lordship,
There is no reference to DV Act in this case.
civic act is not there, my
Then-
my lord, it is ultimately full of law that has been enumerated under what situation the revisional power can be accessed. Only one point is that, my lord, provision of law if not applied. My lord. My case is on that. My lord. Paragraph 12. The jurisdiction of the court under section 397 can be exercised as to examine the correctness, legality, or propriety of an order passed by the trial court of the inferior court or the inferior court, as the case may be. Though this section does not specifically use the expression prevent abuse of process of any court or otherwise secure the ends of justice, the jurisdiction under section 397 is very limited. One, the legality, propriety, or correctness of an order passed by court is very foundation of exercise of the jurisdiction under section 397, but ultimately it also requires justice done. The jurisdiction could be exercised where there is a palpable error, non-compliance with the provision. My case is that it is the case where the law has not been properly applied for. Another citation, my lord, because my learned senior friend is insisting upon that I have to prefer appeal, my lord. It says, my lord, if appeal required, my lord, then I have to challenge both things, facts as much as law. But I'm not touching here, my lord, facts. I'm only touching the law, my lord. Therefore, my lord, it is not the case that this regional court has no any jurisdiction, my lord.
Who says only all facts and law both have to be challenged in
My lord,
appeal?
this one, I have this citation. Case of appeal, I have to go, I have to test both of them.
Which he wishes to raise. If there is no question of law, fact to be raised,
My lord,
you will raise only the
my lord,
question of law.
my submission is that, my, if suppose I place anything, my lord, in regard to the, my lord, merit of the case, my lord, my revision petition prima facie is not maintainable. If suppose there are disputed facts, I raise before this honorable court, my lord, my revision petition not met. But here is a case, my lord, out of which, my lord, I am raising only law point, my lord, that in terms of section 31, case of non-compliance, this power has to be exercised. But see, one more clarification, my learned senior friend is saying, in terms of rule 6, sub rule 5, that the section 12 application followed by section 125 CRPC. Yes, correct, my lord. But lordship, this special law also indicate that in case of non-compliances, then section 31 will come into play, my lord. It cannot be bypassed. And section 31, if suppose is the part of that, my lord, special legislation, then, my lord, it has to be invoked. Instead of that, my lord, bypassing this special legislation, the section 125 subsection no role to play, my lord. This is only the clarification in respect of rule 6, sub rule 5. My lord.
Is all?
Deeply aware.
Correct. CAV.
Deeply aware.
Much of.
But my entry mode is there, that may continue, my lord, till my entry mode is there, that may continue till, my lord.
Is it only till today? See. Check. To be understood, I have
But,
never
my lord,
come across a
otherwise,
practice of
because the trial is
extending interim order till delivery of judgment. Yes.
otherwise, my lord, the trial court is there, my lord, because that is fixed. That's why, my lord.
Okay, we'll see. Yes.
Deeply aware.
This jump between file man for considering the pay granted to the state party number 2 matter. For the first fire matter, the FIR has a file matter 8823 matter, but in part done. Base emails.
Yes.
Very much.
FIR
Yes, ma'am. Base 60 minute,
1660.
60 minute. The FIR minute.
Yes.
File against the number. Company email. It's his name is Malak. Nilong Kaisab Malak, alias Mal Tom Medhi Malak. Here Malak, we have used Malak. His name is Nilong Kaisab Malak. He misappropriate Malak. Here about Malak. He made up this. Now, my lord, in connection with this case, my lord, father was, so my lord, arrested. That is case 71 is the forwarding report. Forwarding report is this.
Where is the order of bail?
Yes. Page 133, my lord. Very well. Supplementary case record is prepared as the origin. This person, namely Nilam Medi, as Nilang Kaisab, about basic connection. In the forwarding report, arrest or not. Last paragraph. I have perused the count of arrests estimated in the forwarding report. It is seen that the accused the pandemic was a go down. Accused is also the office in charge of the Sonali Food. The arrest of the accused file of 9 has to prevent committing further of it. The petition on behalf of the accused Medi. Now it comes for the accused that case. However, the IO is absent. They are not produced. Case of there is no record that not has and regarding the case and observe the guidelines has not been in all aspects. The case out or 30,000. Like now the bail petition prepared by the for the number this case 129. Yes, Himala, he has specific ground. I am not the accused person. Pandemic. Been said by him. Case 1. Kindly see his name, Nilam Medi, son of Pamun Medi.
One 129.
Yes, madam.
Yes, Nilam Medi, son of Pramod.
Pamun Medi. The FIR is Nilam Kaisap. I will show Mela how the person is the one and the same person.
Is there any dispute with regard to that?
Yes, madam. For me, madam, there is no dispute. The same person. But he has taken Mela, he is not a FINM accused. One Nilam Kaisap is FINM accused. Now, page 130, madam. Para 3, madam. Next page, madam. That the applicant begged to state that his son Nilam Medi, the father has filed this bail petition, madam, has been picked up by the Atigaon police on 30/10/2024 in connection with the above noted. The arrested accused person, not FINM accused person. He is not an employee of the Ellis company. The FIR has been filed against the sister-in-law of the present accused, namely Dipsika Sodori and one Nilang Kaisap. During investigation, the police arrested the younger son of the applicant, namely Sudarshan Medi. Subsequently, he was released on bail by the Honorable Court by order so and so. The FIR has been registered under section so and so for maximum punishment up to 7 years. Therefore, a notice under section 1 35(3) BNSS has to be served upon the accused before arrest. But in this present case, the accused person has been arrested on without serving in under section 35. The 2 point here. Now, whether this has been served upon him, also from the High Court order, his bail was taken.
114.
Uh, First of all, kindly see balloon 111 my lord. Where from time was granted my lord. Next are 60 my lord. And in the custody my lord, kindly see Nilam Medhi my lord. There is no further step. Only when the address has been given my lord. Now in 112 my lord, in the same submission. In para 4 my lord, Mr. R.P. Somal Lawrence, Senior Counsel for the applicant, submit that the name of the applicant finds no mention in the FIR. On 112 my lord.
Yes.
But he appears arrest as his elder brother, namely Sudarshan Medhi, was arrested here in this case, and he has apprehension of arrest. He approached this court for granting him the privilege of entry. His father submitted that the applicant is ready to cooperate with the correct. Now, on the basis of this submission, my lord, claim was granted. On 140 my lord, final 11 para, is it para?
Anyway, we are not on the question of the identity of Nilam Kashyap or Nilam Medhi. Bail has
But
been
he has
granted to
disputed,
Nilam Medhi.
But he has disputed that I am
Whatever.
not the Nilam Kashyap, my lord.
It is his bail that we are considering now.
Yes, my lord.
Bail granted to Nilam
Yes.
Medhi. So, and that ground is technical.
My lord.
Bail is granted on technical ground.
Yes,
That is all what we have to see.
Yes, madam. Whether my lord 41 nothing has been issued or not.
We are
my
now
lord.
not concerned whether Kashyap and he is
Yes,
the
ma'am.
same person.
Then my lord, kindly see, my lord. Page 119, my lord. There are 12 and 13. There are 13, my lord. In respect of my lord, the 49 notice. The learned public prosecutor has pointed out that the IO has issued a notice under section CRP Nilam Medhi alias Nilang Kashyap 17/9/23, directing him to appear before the IO on it, but the petitioner has not complied with this order. It is also submitted that in order to conceal his identity, petitioner Nilam Medhi has the name of his father in the custody as well as the bail application filed by him. So far his identity, para 60 Madi, observe my lord. Same person. Now, page 120, my lord. Para 16 and 7. Page 120, my lord. Regard to my lord. Tip of the this one. Here it is, last. In view of the above, it feels that the interim period's bail was granted to the petitioner on misconception of fact that his name of the petitioner has the. And a senior counsel for the petitioner obtained the interim order by in the court is definitely a count of vacation or cancel. It also appears from the case that the petitioner has not provided with the invitation, right of receipt of one and not. The petitioner did not appear before the IO. Also,
You reading?
yes, ma'am.
Which para?
Para 21 or 122. Page 100. This order, my lord, against filed against this order, my lord, they have not preferred any asset. Again, my lord. This already seen, my lord, the grounds he has taken in the bill petition. I have not received the photo note. Check my lord, he received the photo note. Page 123, my lord.
Yes, yes.
This is the forwarding report.
123.
Yes, ma'am. On the ground of arrest, my lord, we start from my lord, page 124, my lord. From bottom, my lord. The accused person is a FI name.
This forwarding report is in respect of this
Yes, ma'am. The
Neelam Medhi.
Neelam Medhi.
Yes.
The second government is the arrested accused person was alleged to be in trust and is also the office.
Yes, we have seen the grounds.
Yes,
Yes.
ma'am. Now, my the so far the 41 notice is concerned, madam. Plus 6. Earlier notice 41 JRPC have been served to the accused person earlier, but he had not responded the notice. Come in upon the accused. Is that push, madam? I will put my any pilot. He has not received the photo notice or police has not received the photo notice. There, my lord, without the photo notice, my lord, whether his arrest is necessary or not, my lord. Then the fact, my lord.
Is the case diary available?
Yes, my lord. Last October was received, my lord.
It appears that the learned magistrate held that no notice was issued without seeing the case diary. Means, huh? Yes, magistrate says case diary is not produced and there is no record notice has been sent to the accused. In the court record, that notice may not have been there, but it would have been in the case diary. So, yes.
In the count of arrest, my lord. Yes, sir. Says that, my lord, if there is no necessity to arrest the accused, my lord, then my lord, photo notice is being issued, my lord. Even if for arresting a person, my lord, down has to be reflected in the checklist, my lord. The checklist, my lord. This has categorically stated, my lord, the prime accused. For the order passed by the learning. No opposition was given to the, my lord, public prosecutor also, my lord. Or, my lord, 4 of the, my lord, 47, my lord. Now it is great. 4, my lord.
Yes.
I am taking, my lord, the section 484, my, please, my.
4?
480 my lord.
Yes.
Office to 4 my lord.
CRPC,
Yes. KRPC 30. Now it
BNS.
is 480 my lord. My book my lord is page 119 my lord. 480.
Yes.
When any person accused of or suspect of commission of any non-bailable offense arrested or detained without warrant by an officer or appears or is brought before a court, pardoned in the High Court or court of release, but accept. Now by that proviso, my lord, provided also that no person shall, if the offense is to be committed by him, is punished for life, imprisonment of for 7, as is punished 7 or more, be released on bail by the court under this subsection without person of hearing public. This opportunity was not given to the public.
Yes.
Now, my lord, the what you are not concerned, my lord. I am relying to it is when person my lord.
Para.
Para my lord, 9 my lord.
Yes.
Married my lord. The under provision that is 41 is here with unnecessary arrest or threat of lies on the realize for when in the the aforesaid provision makes it clear that in all cases where the arrest of a person not required on a one step officer is required to directly take place and time or oblige task activity place which comes arrested is police officer is the at this stage of the condition petition for arrest as a shall be subject same is it care of the opinion the is the no is course wrong by the first and the number of comes to front of like to or mechanically also and discontinued. Our endeavor in this husband is to the officer to address the in order to ensure what we have observed about the directions. Number 11.2 my lord. All police officers be provided with the checklist containing the step under section name. Police officers shall forward the checklist be filled and furnish the reasons and material associate the while forwarding the for the further. I am happy on this. The magistrate while authorizing the detention of the shall peruse the report furnished by the police officer in terms of the F. And only after recording his satisfaction, magistrate shall authorize the decision not to arrest an accused be forwarded to the magistrate with notice of appearance in terms of 41 CRP staff on the which may be extended by the superintendent. Now, kindly order passed by the line kilometer because the ground of arrest. Why it necessary? And for my lord, if we put in that photo has not been issued also, my lord, in the ground of arrest, my lord, arrest is necessary, my lord.
Yes.
So far, the cancel some basis acted upon. I'm relying my lord one and to 4 years equal to got in, my lord.
Yes.
Para 10, my lord. 10 and 11, my lord. Married, my lord.
Yes.
While cancelling the bail granted the appearance, however, we are above that apart as well. Under sector 20 section 201 empowers the High Court as a subsection direct any person 239 female PNSS empowers the High Court direct any person who has been released on of the be arrest that to the power of cancel the bail to generally the ground for cancellation of the are 35 interfere with the court. Attempt to tamper with the evidence with interacting. But there is likelihood of attempt to make him by going underground, coming unable line. Attempt to place himself the reach. These grounds are lasted and not. A bail has been granted and once it is after by the filing of price. Have the cancel on found that the error is that the however in last one very down
Which
Now-
part are you reading now?
para 10 minutes. Abdul Basti case has been referred. Now in the para 16 month, Gursan Singh case. algorithm. Parasite.
Mm.
Court has scientifically explained the provision regarding the cancel bail under the called out the difference from the and the stated the power of the court and cancel the bail. Section 400 the new first is for on regarding was also the position under 498 of the old. That is to say, even if a subset and inappropriate clearly under section High Court of the direct to be arrested and committed in full code 482 was ordered in somewhat different language when it stated that the High Court of the cause any person has been bail under section 1 be arrested and may commit custody. In other words, under section 90 of the old person had been admitted to bail by the High Court to custody by the High Court. If a person admitted to bail by the Court of the Court of Section that could commit him to custody. That's already admitted to custody. That would under section 400 of the new code, High Court may commit a release on bail under section 23 and put the custody. It must, however, be made clear Court of Section cannot cancel a bail has already been granted, right? Unless the new circumstance during the process of trial after an accused person. If, however, a court an accused person bail that has earlier. Really, therefore, to the court in the superior court under section commit like when, however, the decline of and except those already exist. Well, for in like আমার তারপরে 18 minutes. Vibrating the effort is put in the present and this serve. There's also this the concept of a sudden illegal perverse or order of the copyright.
Yes.
There is also a distinction between the concept of a sudden unjustified illegal or perverse against or bail on the ground. If the order granting bail is a perverse pass on illegal materials can be annulled by this. Therefore, the concept of setting the unjust or perverse or count of two adverse fact having surface after granting by such cancel then ask by the course until all these judgment come to para 11. So is well settled by the getting of judgment required by this that of for grant of bail cancel thereof are entirely dependent. Bail granted to an
Anyway, we have gone through that already.
I am harping on this P and D method. The bail was granted in ignorance of the power of the court and second method. The bail was by the fraud. First one, give the notice. And
Yes.
without telling the melody order of the High Court, in melody case, I am not getting. I am not the person. That two different person. I'm related. Here about the para 9 method. What are the factors to granting bail method, para 9 method? I mean, method clause 5 method, the character, behavior, means, is thing of like
Yes.
the last one, low term standard. The para format, para format. Is by if the accused attempt interfere with the course of justice, can be cancelled.
Yes.
What is just I mean, what is behavior, character, how he missed the code, my lord. He has not come to court, or the trial with clean hands. Only in a favor of my lord, the court also. Same, I pray, my lord.
Yes, respondent.
My lord, my first, my lord, my lord, this revision petition, my lord, is not maintainable. This revision is filed by the informant, not by the state. And there's and it is settled law, my lord, that bail order, my lord, is considered to be an interlocutory order. And the Honorable Supreme Court, my lord, held that it cannot be, my lord, challenged in revision, my lord, as there is a clear bar. In this point, my lord, I am relying the judgment of the Honorable Supreme Court, my lord, reported in 1977, 4 SCC 137, paragraph 6, my lord. Paragraph.
Which, what is the relevant provision of law regarding preference by state and not by informant?
Lord, my learned friend said that I have, my lord, misleaded the
No, your submission that it is not maintainable
lordship.
because
my
it
lord,
is not preferred by state section.
and this revision petition has been filed, my lord, under section 438 of BNSS.
We are not asking that. We are asking what is the basis of your submission that it cannot be preferred by the informant.
No,
but
he
only
cannot,
by
he
the-
can file, my lord, but revision, my lord, under this section is not maintainable. Because he has taken the point, my lord, that I have, my lord, mislead the honorable court, I have suppressed the material fact, I have, my lord, I have, my lord, not cooperated, investigation was not, my lord, I have not cooperated. And all these things will supported by the case diary, my lord. And in vital point, my lord, the notice, my lord, under section 41.
You were saying that he cannot file a revision petition, but he can file, but
I
not
am
by
saying,
way
my
of a
lord,
revision.
revision is
petition.
not filed by the state. It is filed by the informant.
Yes. What is
And
the
there is a
provision?
bar, my lord, because, my lord, bail order is considered to be an interlocutory order.
Hmm.
And the Honorable Supreme Court, my lord, said that revision is not maintainable. He
What
can,
then what is maintainable?
my lord, he can say, file, my lord, petition for cancellation. Is a defined procedure, my lord. Cancellation of bail is defined footing and revision is, my lord, in defined footing.
Is there any separate nomenclature for such a petition in a high court?
But the cancellation, my lord, the ground of cancellation, my lord, the Honorable Supreme Court has laid down the guideline.
No, I'm
If-
saying if
Lordship,
suppose
if, my lord,
suppose he files an application for cancellation,
Lordship,
what is it going to be registered as?
and it will be not, my lord, under section 438 or as criminal petition. Because revisional jurisdiction
Let
and
us see what this has been filed under.
Lordship.
It is filed under, my lord, section 438 ENSS, read with 440 ENSS as well as 480. That is 402, my lord.
And
And
all the
section
sections,
528
my lord,
ENS.
cannot be clubbed.
483, my lord, earlier, my lord, is 400.
Lordship has seen, my lord, the bail was granted on the ground that 41 notice has not been complied with, as, my lord, as per the Honorable Supreme Court order. So it will reveals from the diary, my lord, whether the notice was served upon the petitioner, my lord. If no notice was served, my lord, there is no point, my lord. And if my learned friend can show, my lord, from the record that I have received by acknowledging the 41 notice.
But in the bail order, it has been held by the High Court that notice has
That
been
was, my
served
lord,
upon.
wrongly,
You did not
wrong
get it
information was
corrected.
provided at the 438, my lord. Because that petition was under 438, my lord, anticipatory bail application. Anticipatory bail application and after arrest, my lord, there is two difference, my lord. Correct information was not furnished to the Honorable Court, my lord. After the Arnesh Kumar judgment, my lord, the Honorable Supreme Court, my lord, held that any violation of section 41 is, my lord, accused to be entitled for bail.
Receipt is not there.
Now the bail was granted, my lord, on 31/10/2023. And in the meantime, my lord, charge sheet has been submitted. So I will cooperate with the trial, my lord. And nothing to be investigated in this case.
And what is your reply to his contention that even if section 41 notice is not there, then also say in the given grounds, police was justified in arresting?
My lord, this is, my lord, it will be, my lord, against the, my lord, judgment of the Honorable Supreme Court, my lord. Because the maximum punishment is less than maximum 7 years, my lord.
Yes.
The ground of arrest without, my lord, when 41 notice is not complied with, then, my lord, that ground will come, my lord. I am not cooperating with the investigation. Notice was served, I am not appearing. And in the forwarding report, my lord, the IO has written, my lord, that notice was served. This is also, my lord, wrong information was given, my lord.
Yes.
My lord, regarding the violation, my lord, after Anesh Kumar judgment, my lord, 2022 10 SCC, my lord, SK until judgment, my lord. Summary is, my lord.
What is this? What was this earlier one? Amarnath?
Amarnath, my lord, regarding, my lord, mental liberty of
Para?
para 6, my lord. Para 6 in the last sentence. The main question which false determination of this appeal is to whether as to what is the condition of the terms interlocutory order as appearing in subsection 2 of section 97, which bar any revision of such an order of the High Court by the High Court. The term interlocutory order is a term well-known legal significance and does not present any serious difficulty. It has
No,
been used.
he has filed this application under 483 subsection 3.
No, first, my lord, main petition filed under section 438. Now, my lord, it was earlier 397.
Oh, it's read with 483
Lordship.
3. So
Now, when there is a provision for cancellation of bail, my lord, under section, my lord, 483, inherent.
he has included all the provisions by way of abundant caution.
Whether, my lord, the honorable court will.
Application, my
Hmm?
Inherent power will come, my lord, when there is no, my lord.
He can
Other-
give up the other sections. He can stick to this one.
Other, my lord, remedies, my lord.
No, according to you, under what section should this petition have been filed?
My lord, he could have filed cancellation as, my lord.
Give the section.
483, my lord, 483(3).
Yes. That is there.
No, he has not filed for cancellation, my lord.
For what?
For setting aside entire order, my lord,
Yes.
on merit, my lord, not on technical ground.
483 does not mention about cancellation.
483, my lord.
Yes, 483, High Court or Court of Session may direct that any person who has been released on bail under this chapter may be arrested and committed to custody. So that is the language he has used. Yes.
So, my lord, I have not violated any terms and condition. And I have not played any fraud. The learned trial court, my lord, by exercising jurisdiction on, my lord, and for violation of the, my lord, procedure laid down by the Honorable Supreme Court, my lord, granted bail. Investigation has already been completed, my lord.
Yes.
So, my lord, further custodial detention or interrogation, my lord, in this case, my lord, is meaningless, my lord, because trial will be started, charge sheet submitted.
All right.
My lord, relevant petition is liable to dismiss.
I'm relying my lord, the here also, my the petition has been 591, as well as 439 and 483.
Hmm.
Except I have also filed. There are 1 in minute, 3 minutes.
Schedule. In deserve. What is the decision?
No, I have
Last one he has given.
the 20 SEC online Guwahati 939.
Top. One I have not marked. Let me see. No, it's not here.
Here also, my the helmet, peda 1 minute represent file minute, peda 3 minutes, what are the section minute, book minute. Everybody ordered of period is government paper. Read it 401 as well as 409 and 480.
All right.
Obliged, man.
All right. CAB. Yeah. Yes.
Asking of an FIR lodged other occasion that while I was a minor, I obtained by application fraud my birth certificate. Can I take a lord's para page 15, my lord? And next, page 15 is the relevant page.
May I read? With due respect and honor, the undersigned takes from you that ago has come to knowledge of the undersigned that one Inuspa has obtained a birth certificate from the municipal board by registration first dated 3rd July 1988, wherein the name of the father is known as Mr. Moni Kumar Suba, name of mother is
There another side,
my lord.
who is representing the other side? Who is?
Wait, my lord, because well, we will try to. We will
Yes,
try-
yes, you continue.
Further, the date of birth of said Minupa is shown as 16th of February 1988. It mentioned here that the undersigned has no daughter in the name of Suba. Moreover, the undersigned got married with Mani Kumar Suba in the year 1991. Hence, the said birth certificate is a false one, which was obtained by Minu Subba by submitting forged documents for the authority concerned. That, sir, as my husband was a former member of parliament from Lok Sabha and a renowned person, so said Subba has illegally, we have informed they are has illegally and unlawfully used our name with a view to cheat people and to gain herself wrongfully. After coming to know about the said fraud, I tried to contact the authority of Tej Municipal Board but failed to get desired response from their end. Therefore, I humbly request you to register a case against said Minu Subba for committing offence of cheating by personation and take strict action against her as per provision of law. My lord, who has filed this FIR? My mother. When? On 23rd of February 2023. Now, when the birth certificate was issued, it was issued the year, my lord, 1988. Now, kindly come to the birth certificate, my lord, page 7. The date of birth as per the birth certificate, my lord, is 11th of February 1988, and it has been issued by Tejpur Municipal Board on the left side, my lord, bottom, and the date of issuance 6th of July 2001. At that time, my lord, I was only 13 years of age. Now, a birth certificate is generally applied by the parents, not by the child. Kindly see the next annexer, my lord, annexer 3. This is only a
No, last one, birth certificate is annexure.
my lord,
Page?
annexer, birth
Page?
certificate is annexer 2, my lord, page 7, 17. This birth certificate has been issued by Tej Municipal Board since they are also registering authority. My lord. There are many authorities who register birth deaths. One of them is Municipal Board. Panchayat is also there. So we kindly take note of the date on which it was issued, my lord, 6th of July 2001. And the date of birth is 11th of February 1988. So in the FIR, it has been written as 16th of February, 11th of February. The next annexer, my lord, page 18, a statement of marks I had obtained. This is only to show that I studied in Mussoorie International School. I was a student at Mussoorie, my lord. The next annexer is also the pass certificate issued by the school. Now, what is interesting, my lord, is the next annexer 5, page 20. Way back in 2006, my lord, on 23rd of March 2006, my mother had written a letter to the principal of Mussoorie International School. Kindly see signature on the bottom, my lord, as mother. Address, kindly take note, 118 Subba Farmhouse. He has spoken about the marks that I have obtained and also that in future he intends to send me to a school abroad for my further education. Now, annexer 6, my lord, page 21. This is my Aadhaar, where my date of birth is mentioned, 7th of February.
same date. Annexure 7, my voter I card, my lord. Father's name, Mani Kumar Subba. Page 22, Annexure 7, my lord. And date of birth, same, 11th February 1988. Father's name, Mani Kumar Subba. So my mother also says that I claim to be the daughter of Mani Kumar Subba and also of Jyoti Subba. Annexure 8, my lord, page 23, my passport. Date of birth is same, Manu Subba, 11th February 1988. And kindly see the next page. Same address, page 24, my lord. Father's name Mani Kumar Subba, mother's name Jyoti Subba. Address same, Subba Farmhouse, 118, New Delhi, Mangalpuri. There are other passports which was renewed, my lord, page 27. Same information was again reiterated. Now kindly come to Annexure 9, my lord, page 28. My father was a MP, my lord, from Tej Lok Sabha constituency for 3 consecutive terms. And as a representative of the people, he had to submit an affidavit, my lord, under the People Petition Act. It is mandatory in nature. Annexure 9 is that one of the affidavit which I have in my hands. Kindly see the next page, page 29, my lord. The table, Mani Kumar Subba, Jyoti Subba, Tilmaya, Inu Subba. The 3 child are 4, 5, 6. Wives are there as Jyoti and Tilmaya. Kindly come to page 31, my lord. Same and affidavit, it continues. The next table, Mani Kumar Subba is father, Pau Jyoti, Tilmaya next, Inu Subba daughter, Chirag Subba son, Roshan Subba another daughter. Page 33, my lord, on the same table continues. Mani Kumar Subba's wealth, Jyoti Subba, Tilmaya, their wealth has been described as what assets they do possess as on the date of preparation of the affidavit. So this affidavit continues even at page 38, my lord. With different information, but showing my father as Mani Kumar Subba, mother Jyoti there. My marriage card, my lord, page 39, Annexure 10, also has the same address, showing my mother and my father as Mani Kumar Subba. On lodging of this FIR, my lord, the police started investigation and also started looking for me. Therefore, I had to approach the alternate trial arrest bail. Interim bail was granted to me by Annexure 11, my lord, which was made absolute by Annexure 12, page 48. May I take your lordship one observation at page 50. Last but one paragraph, my lord. During the course of investigation, IO is stated to have collected the register of birth from Tejpur Municipal Board for the year 2017-18, whereas IO annexed with the case diary photocopy of registration book of birth and death for the year 1980. So he mentioned it wrongly, but actual birth and death copy has been obtained. Page 50, my last but one para. During the course of investigation, IO is stated to have collected the register of birth Tejpur Municipal Board for the year 2017-18, whereas IO annexed with the case diary photocopy of registration book of birth and death for the year 1988, which does not divulge any information that present accused obtained her birth certificate by any extraneous means. So far, IO made no dent in the name of investigation regarding commission of the alleged offense by the accused.
Yes.
So, my lord, what has happened, even for argument's sake, my lord, if we assume that the birth certificate somehow is having some wrong information, can I be blamed for it when it was issued in the year 2001, when I was only 13 years of age? If any blame is to be put, my lord, with all respect to my departed father, it either should go on him or to my mother. Now, what has happened, my lord, after his demise? Unlike any other family, the dispute arose amongst the siblings with the mother as to the division of the property. Somehow I got enraged, my lord, I lodged 2 FIRs, where I wrote that my mother was a kept of my father. And thereafter everything followed. Now kindly come to their reply. They have submitted this actually shows. Therefore, while filing our criminal petition, my lord, this time we avoided any sort of sentence which can further annoy my mother. There in Delhi, they wrote something which ultimately annoyed her, for which she lost the FIR. Now kindly come to their reply, my lord. They have submitted 2 counter affidavits, one after another. It starts at page 52. May I take your lordship to the relevant page? Paragraph 9, page 55. So far my documents are concerned. Para 9, my lord, with regards to statement made in paragraph 7 and 8 of the petition, respondent in reply begs to state that merely in of name in the form of affidavit or name mentioned in marriage reception card thereby itself do not confirm relationship. I pause for a moment. You are not disputing the affidavit submitted by Mani Kumar Subba, which was a statutory affidavit. You simply say that because your name is reflected there, that doesn't mean that you are daughter. That is what they want to say. But is there any averment that this affidavit itself is wrong and it was submitted by late Mani Kumar Subba? Now, I had never compelled my father to show myself as a daughter. And so many statutory documents are available with me. You are not pointing any anomaly in any of the other documents, save and except birth certificate. Thereby itself do not confirm relationship, and as such, no conclusion can be drawn that the paternity of a person is proved. This respondent further reiterated that she is not aware of any such invitation card. Now, my lord, in the FIR, is there any averment or any allegation that Mani Kumar Subba was not father? Only claim is that I am not mother. I married Mani Kumar Subba only in the year 1991, and the birth certificate is of the year 1980. That is her claim. May I again show your lordship the FIR? Page 15, my lord. With due respect and honor, the undersigned begs to inform you that a few months ago has come to knowledge of the undersigned that one has obtained a birth certificate from Tej Municipal Board by registration person dated 3rd July 1988, wherein the father is as Mr. Mani Kumar Subba and name of mother is as Mrs. Jyoti Subba. Further, the date of birth of said Subba is as 16th February 1988. 2 dates are wrong, my lord. First, 23rd of July 1988 ought to have been 23rd July 2001. And second, 16th February 1988 is 11th February 1988. As per the birth certificate. Be it mentioned here that the undersigned has no daughter. Kindly look at the language, my lord. Be it mentioned here that the undersigned has no daughter in the name of Minu Subba. There is no claim that Mani Kumar Subba is not my father. Moreover, the undersigned got married with Mani Kumar Subba's deceased in the year 1991. Hence, birth certificate is a false one which was obtained by Minu Subba by submitting false documents before the authority. She disclaimed herself to be my mother, not that she is challenging my paternity with Mani Kumar Subba, that he was not my father. This claim is not there. Now kindly take the next relevant portion from their objection, my lord, para 14, page 57. The respondent begs to state that the petitioner has made all baseless statements to make out a case. Her stands run contradictory from one proceeding to other. The petitioner only aim is to grab the property of the husband of the respondent making some false claim. This aspect is apparent from the way she lodged an FIR before Mehrauli police station against the present respondent, which she would not have done had she would been her mother. Now that is only pain of my mother, why I lodged an FIR against her before Mehrauli police station, where for some wrong advice I said that she was a capt of my father, and I am born out of that. So my claim there was that she cannot have any share in the property left by my father because she was not married woman. But since even if I am an illegitimate child, I have a right, the property of my father. Now, another objection that they have submitted, my lord, that starts at page 63. Kindly take into account para 3. During the pendency of this criminal petition, my lord, they made an application under RTI before Joint Director of Health Services in order to verify the birth certificate. So they have assumed the charge of the investigating officer, and they have stated in para 3 like this, that the deponent begs to state that in the present case, the police in search of truth has sought for verification of the birth certificate as per registration number 1679 dated 23rd July 1988 from the Office of the Joint Director of Health Services, Tejpur, and the Office of the Joint Director of Health Services, Tejpur, White communication dated so and so informed that the birth certificate as per registration number so and so is registered in the name of one Alakesh Das Rai, Rubber Bagan, Tejpur. Thus, prima facie, it appears that there is something wrong for which the trial is necessary and the petitioner to be proceeded under relevant provision of law. And they have also annexed the documents, my lord, as Annexer B, page 67. Kindly have a look. With reference to the subject cited above, I have the honor to inform you that the birth certificate which was issued by Tejpur board in the name of Subba, daughter of Mani Kumar Subba and mother named Jyoti
There is a
Subba,
second.
my lord, page
Second
67.
affidavit.
Additional affidavit.
Find it here. It ends at page, this is only one affidavit is there, it ends at page 61.
The last was not there, for which there was a
File on 2710, Lordship.
Hmm?
On 2710.
2710. Anyway, you submit. Get it. Have an extra copy?
Lordship, can you play?
So may I read again para 3, my lord, page
Yes.
that the deponent begs to state that in the present case, the police in search of has sought for verification of the birth certificate as per registration dated 3rd of July 1988 from the Office of the Joint Director of Health Services, Tejpur, and the Office of the Joint Director of Health Services, Tejpur, White communication dated 10th of May 23 informed that the birth certificate as per registration number so and so is registered in the name of Sri Alakesh Das Rai, Rubber Bagan, Tejpur. Thus, prima facie, it appears that there is something wrong for which the trial is necessary and the petitioner to be proceeded under the relevant provision of law. Now, the relevant annexer is at page 7, my lord, which they have annexed. this appears to be a response and against an application under RTI. With reference to subject cited above, I have to inform you that the birth certificate which was issued by Tejpur Municipal Board in the name of Mithu Subba, daughter of so and so, mother named Jyoti Subba, against registration number 1679 dated 3rd July 1988, is date of birth is 6 February 88. After verification from our office record, it is found that no such record is available in the name of Miss Ninu Subba. But as per office record of 1988, registration number 179 was recorded against the Alaklesh Das Rai Rubber Bagan, which is enclosed for your ready reference. Regarding the second copy of birth certificate, the same was issued. This is very important, my lord, from Tejpur Municipal Board without any consent to the undersigned. Now, my lord, if Tejpur Municipal Board has issued the birth certificate, and if you are trying to find out at the Office of Joint Director of Health Service, where from the verification will match. Now, again, I say under the Birth and Death Registration Act, my lord, the state government has the power to delegate it to different authorities to register birth and to register death, and also to issue certificate.
So you
In
mean
my-
to say that this registration number 1679
is issued by all the authorities. Same number they keep following, my lord. Panchayat office, they will also issue certificate. Tejpur Municipal Board, they will issue certificate. PSC, the government PSC, they will issue certificate.
So a
Joint
similar
Act-
registration number will be
Yes,
available
my lord.
everywhere.
Now, if my certificate has been issued by Tejpur Municipal Board, instead of going there, you are trying to find out somewhere else. You go first at the office which has issued. Therefore, the authority himself says regarding the second copy of the birth certificate, the same was issued from Tejpur Municipal Board without any concern to the undersigned. As such, no relevant record is available at the Office of Joint Director. Now, my lord, I kindly again come to their second objection. I refer to para 3, my lord. Kindly come to para 4, page 65. Para 4, my lord, page 65. That the petitioner has made different statement in different proceeding. So here, in this proceeding,
Yes.
she projected that the respondent number, her mother, is married, late Mani Kumar Subba. However, a suit filed by her before the Honorable Court of High Court of Delhi, she stated that respondent number 2 was having an extramarital affairs with late Mani Kumar Subba, and the petitioner was born out of such relation. A true daughter could not have used such words, remarks against her own mother if she was the one who has given her birth. The respondent craves leave to produce and rely on the copy of the plaint whenever so necessary. Now, my lord, I agree that at one place or the other place, somehow for some wrong advice, this kind of statement was made. But for that, can you lodge an FIR as a counter blast, my lord, and say that this birth certificate is doesn't belong to Minu Subba, or Minu Subba should be blamed for this birth certificate? Now, if any blame, my lord, again I say with all humility that if any blame is to be taken or owned, either it has to be by my departed father or by my mother. If I somewhere at some place I had made some wrong statement which has caused hurt or annoyance to my mother, for that can she resort to a criminal case and use it as a counter blast, my lord? Now, my lord, in such a scenario, and also taking into consideration, my lord, that when this was issued, I was only 13 years of age. So, taking the entire facts, my lord, consideration, a 13-year-old at least cannot be blamed for any anomaly if it is there in the birth certificate. And what kind of investigations he wants against me? The police, instead of acting unbiased, they started acting as the agent of my mother, with all respect, my lord. And now, therefore, my lord, in this particular case, he has also referred to that in this criminal petition, we have not said anything. Why? We chose because ultimately, my lord, our intention should never be to annoy my mother. This all started, my lord, again I say, only in connection with the division of property, where somehow someone advised that if an illegitimate paramour or wife was never legally married, there her child will be legitimate, but she won't get any share. There are certain judgments, my lord, where when FIR is lodged as a counter blast, what is to be looked in, honorable court knows is, my lord, relying on judgment of Muhammad Ali versus State of UP 2023. May I place all the judgments together so that I can refer one by one?
Yes.
There- My lord, I am confining myself to 4 judgments. But first of all, may I pray you to look into Registration of Birth and Death Act 1999. I have provided, my lord, copy. Section 27, my lord, the state government may by notification of the official gazette direct that any power exercisable by under this act, save and except make rules subject to such conditions, if any, as may be specified in the direction exercisable also by such officer or authority subordinate to the state. By virtue of this section 27, my lord, government of Assam has delegated the power to Panchayat, TSC, municipal authority along with the joint director, my lord. This is only to indicate that such powers do exist, my lord, and otherwise also, this is not the proper forum, my lord, to challenge the authority of the municipal board to issue any certificate. Now, may I refer to the judgments which I was trying to refer, my lord, Muhammad Ali and others versus State of UP 2023. Live law as Muhammad Ali, my lord, 2023 live law as page 613.
Yes.
This judgment, my lord, refers to the well-known judgment of State of Haryana versus Bhajanlal. So far, the passing power as to when and how to be exercised has been defined. Para 11, my lord.
Yes.
Subpara 1, where the allegation made in the first information report or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the accused. Now, my lord, even if the entire FIR is taken as true, what offense do I have committed as a minor at the age of 13, my lord, while making any application or getting any birth certificate? If anyone is to be blamed, it will be other than me. I don't want to say who, because again, this will create another annoyance to my mother because perhaps going live. So, my lord, he may take it otherwise. Para 6 and 7, my lord. Para 5, 6 and 7, where the allegation made in the FIR or complaint are so absurd and inherently improbable on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground to for proceeding against the accused. Again, I say, my lord, that 13 years of age, 2001, when this birth certificate was issued, my father is no longer there. He could have thrown light as to who made the application, but at least I could not have gone there. 6, where there is an express legal bar engrafted in any of the provisions of the code or concerned act to the institution and continuation of the proceeding, or where there is a specific provision for efficacy. No, this is not. 7, where a criminal proceeding is manifestly attended with mala fide, or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. Now, my lord, again I say, because their cross objection reinforces my argument that somehow, somewhere, I made a statement that my mother was not legally married to my father. So, my father never made any such kind of distinction. In his affidavit, which he submitted before the Election Commission of India, he clearly says that spouse 1, spouse 2. And thereafter, the names of the children are there. At some place in one FIR and before the Honorable High Court of Delhi, in regard to the property dispute, I made 2 statements, which I have not produced, my lord. Because again, this time we put self-restraint while seeking passing of the matter. Now, since they have produced, only reinforced my statement, my lord, that out of anger because of that particular statement, and which is quite obvious, my lord, I cannot deny that has hurt her sentiment, for which she decided that let me give you a lesson, and she lost this affair, saying that my birth certificate itself is wrong. Therefore, I submitted the letter, my lord. She had written to the principal of Mussoorie International School, where I was a boarder. I studied there as it's a boarding school, my lord. I was there as a student there. And she wrote that the marks are like this, and she needs to be updated so that she can be sent to an educational institution abroad. So this was the relationship once we enjoyed, my lord, but subsequently this mishap has happened, my lord. Kindly come to para 12 of the same judgment, my lord. At this stage, we would like to observe something important. Whenever an accused comes before the court invoking either the inherent powers under Section 482 or extraordinary jurisdiction under Article 226 of the Constitution, get the FIR or the criminal proceeding quashed, essentially on the ground that such proceedings are manifestly frivolous or vexatious or instituted with the ulterior motive for wreaking vengeance, then in such circumstances, the court owes a duty to look into the FIR with care and little more closely. We say so because once the complainant decides to proceed against the accused with an ulterior motive for wreaking personal vengeance, then he would ensure that the FIR is well drafted with all the necessary pleading. The complainant would ensure that the averments made in the FIR are such that they disclose the necessary ingredients to constitute the alleged offense. Therefore, it will not be just enough for the court to look into the averments made in the FIR alone for the purpose of ascertaining whether the necessary ingredients constitute the alleged offense are disclosed or not. In frivolous or vexatious proceeding, the court owes a duty to look into many other attending circumstances emerging from the code. Now, my lord, if you take into account their own statement, 2 of the paragraphs, the first counter affidavit and subsequent counter affidavit, where though they have not produced the petition that is pending for the Honorable High Court of Delhi or the FIR that I had lost, but they have referred to, and they have clearly said that how can a daughter write something like this about her mother? So this shows, my lord, that because of my behavior, she is annoyed, and for which she wants to give me a lesson. To some extent, she has been able to. I regret whatever we had written there. But should I suffer for that, my lord, for an indefinite period of time? The same line, my lord, other judgment, Honorable Supreme Court, 2023, Volume 6, Allahabad Law Journal, page 80. Paragraph 26. I say, my lord, almost same reproduction is there, my lord, with the other Mahmood Ali judgment.
Okay.
So, time and again, the Honorable Supreme Court is saying that if there is personal vengeance, there is personal annoyance, personal anger, FIR which is so drafted, well drafted. In my case, with responsibility, I say, my lord, that so far my FIR is concerned, it is not so well drafted, but definitely the personal vengeance is reflected there. The other judgment, my lord, Muhammad Wajid and another versus State of UP, reported in 2023 live law as case 6-4.
The last one, which para have you referred to?
Para 26, my lord. And present judgment, my lord, is para 29. This is again reiteration of the Bhajanlal judgment, my lord, and thereafter para 30. Almost everything identical, my lord, save and except court sentences here and there. So in personal cases where the personal relationship is at stake, my lord, the FIR has to be minutely scrutinized along with the attending circumstances. Now, in my case, my lord, if the attending circumstances,
Muhammad
Those-
Wajid, you are reading.
yes, my lord,
Para?
para 29 and para 30. The lordship will find that Bhajanlal case and almost identical reference has been given as to how in cases where the relationship are short and such a situation when an FIR is lost, how it has to be looked minute.
Yes.
The last judgment, my lord, is Nitin Ahluwalia versus State of Punjab, 2025 live law, S 9, para 7, my lord.
Para 17.
7, my lord, only 7. The law on the exercise of the High Court's inherent powers under Section 482 of the Code of Criminal Procedure have been repeatedly expounded and reiterated to the point that they not require restatement, and hence we will not go down that route. The scope of exercise to be carried out by the court
this
while
back to him.
adjudicating such an
Make a copy.
application for passing case
Copy. So I think we are done for the time being. We'll
my,
come back
my
at
lord,
2.
my lord.
Lordship, I have a matter at fixed at 2-8 before court number 7. Maybe so I will come after leave.
The case about. What is the cause of death?
Cause of death, my lord, as per the postmortem report, my lord, suicide.
Suicide.
Now, my lord, charge sheet has been submitted, my lord. And in the charge sheet, my lord, father-in-law of the victim and husband, they have been made, my lord, an accused. Father-in-law, he has been granted bail by the trial court, my lord, as part of scan copy of the record. Here, my lord, before us, my lord, the Sahabuddin is the husband. And in other accused person, other case, my lord, item number 17, Rukia Begum and 3 others, my lord, they have not been charged. They are anticipatory bail, my lord. In 17. Bail hearing.
I want to. 13
Hmm?
Some my personal difficulties, but the concern of the other side, I have taken the concern.
1-3.
13-1-3.
I appear for the respondent. Can it be on 20th, 20 of November?
No problem.
All right, I think anyway, we have to rise at 3:15 today, so.
Lordship.
13, when do you want?
On 20th, 20 of November. Deeply obliged.
Non-sir seated is item
On sir, item number 17, my lord.
17, the ladies.
Ladies, my lord.
Item number 17, submitted by learned additional PP, that charge has been submitted, but the petitioners are not named as accused therein. Hence, the instant application has become factual. Dismissed.
Item
17, your name is not there in the charge sheet, so we have dismissed of this. 16, we are seeing.
After some time,
So sometime you may not get any time.
5 minutes.
Once we resume the hearing, there may not be time for this.
as part of law.
This is bail. This is regular bail.
This is bail, my lord.
How many days?
No, since my lord, day of arrest, my lord. He was arrested on 24/9/2025.
24/9. Around 45 days.
49 days.
49 days. I think we can, since others have been granted bail.
Other,
Right. Up. Take it.
Already had learned counsel for the petitioner and learned additional PP. There is an application for bail. And so PCR as called for has been received. It appears that the charge sheet has been filed against the present petitioners, that is the husband and father-in-law of the.
Rafiquddin, my lord. Rafiquddin.
Only one.
My lord, charge sheet has been filed and.
No, this
against whom, my lord?
petition,
Petitioner is only one, my lord.
husband
Husband, yes.
filed against the petitioner number 1, Rafiquddin, as well as his father, Rafiquddin. It appears from the post-mortem report that this present is a case of suicidal death. Further appears that the father of the petitioner has also been granted bail by the learned trial court. The present petitioner has spent nearly 50 days.
59 days, man.
Huh?
59.
No, 49, man.
Arrested on 7,
For 24/9.
23/9.
Then how can it be 59?
24/9, man, mentioned.
49,
24/9.
say about 50 days custody. Having regard to the afforded facts, further detention of the petition considered necessary. Accordingly, the prayer for bail is allowed. 50,000 was priority. It is further provided petition shall regularly participate in the trial. Angela,
My lord, as we may closed, my lord.
Hmm?
Anticipated bail, my That was
That is not such.
Not considered.
okay.
Oh, ঠিক আছে। Outside যাইছে। Other side is not here. You have completed, I think.
My lord. That's nothing more than.
Yes, all right. We'll take up later after the council comes. Take up the bail here.
We have received the case diary, my lord.
Sir, item number 18, Your Lordship, all other family member, Your Lordship. Petition number 1 is the elder brother of the husband, petition number 2 is mother, and petition number 3 is co-villager. And item number 19 is the husband, Your Lordship, Gopur Ali. All are arrested on same day, Your Lordship, total custody 31st days, 1 month. FIR is page number 8, Your Lordship.
What is the allegation?
Allegation victim committed suicide, Your Lordship, but in FIR, they suspected that the accused petitioner killed her and transformed this incident as a suicide. Actually, she voluntarily committed suicide, Your Lordship. And the husband and wife
Where's
reside
the
separate
PM report?
from the
My
PM
lord,
report.
no, PM report is, my lord, yet to receive, my lord. But one of the witnesses, my lord, has stated, my lord, our Muror Pisfale Tezula acid. Postmortem report will be required.
other custody
The
of
report is not there.
No, no, it is not along with the case diary.
other custody of other it may not be necessary at least. These 3 petitions may kindly be allowed to go on with their
They are
other
all,
family member, Your Lordship,
all of the accused persons, my lord, they are FIR.
but they are reside separately from the joint family. And the marriage also took place about 25 years before, Your Lordship. 2 children, 20 years and 22 years. Their age. Daughter got married to them.
Who are you? This petition number
Petition number
18.
18, Your Lordship. Petition number 1 is elder brother of the husband. Now he presently yield, Your Lordship. And petition number 2 is mother of the husband, Your Lordship. And petition number 3 is the co-villager.
Anything against them?
Yes, my lord, implicated, my lord.
Saying what?
Not, my lord, they have not seen, my lord, who has done the crime. My lord. But question is that, my lord, when the dead body was found, my lord, there was some sign, my lord, that there was a bleeding in her from her head. Investigation is pending. Let the postmortem report come, my lord. We'll
Actually,
fix it.
5 days delay, Your Lordship, to lodge the FIR, Your Lordship.
Proceed to fix a short date and
Incident
call for the
Took
postmortem.
place on 10, Your Lordship, FIR license. These 3 petitions may kindly allowed to go on. Husband may keep pending, Your Lordship. Further custody of this 3
Postmortem report may either
cannot be
reveal
dis-
injuries causing death or it may be a case of suicide. We do
Yes,
not
ma'am.
know.
That is why, ma'am.
But since there are no witnesses,
and also reside separate.
inside the house, other than their own statements, what would be available? Their statements are there.
Yes, statement is there, my lord.
What is the version of Hakim Ali?
Hakim Ali said that, my lord, কেইদিনমান আগতে মোৰ ঘৰত বিয়া আছিলে, তাত সিহঁতে কাজিয়া কৰিছিল। মোৰ মা চবৰিন নেচা গফুৰ আলীৰ আৰু মাৰ মাজত কাজিয়া হৈছিল। সেইদিনা ৰাতিপুৱা মই সিহঁতৰ ঘৰত গালি দি আহিছিলোঁ। এতিয়া কুকুম আলী, ৰহিম আলী, বীণা খাতুন, মা খাতুন, মা চবৰিন নেচাও আছিল। আমাৰ পৰিয়ালৰ মাজে মাজে কাজিয়া হৈ থাকে। ফাতিমা খাতুন আৰু মান্নানাৰীৰ লগতো মাজে মাজে কাজিয়া লাগে।
This is a domestic quarrel between the husband and wife. There are
And
three
what
petitions
does this Fatima say?
When Fatima said, my lord, যা মাহিজা খাতুনে নিজৰ ঘৰত নথকাৰ অৱস্থাত পাকঘৰত চিপ লৈ আত্মহত্যা কৰে। মায়ে প্ৰায় 11টামান বজাত ঘৰত আহি দেখা পাই ৰছীডাল কাটি দিয়ে। The matter is fixed after the week, my lord, call for the postmortem.
That was the old age that you 65 years. At this stage, you this petition may kindly allowed to.
Who cut the rope? Mother.
Mother. That is, my lord, the petitioner number 2, my lord. Obiron Nessa, my lord. He first witnessed the, my lord. He first witnessed the victim.
The custody may not be necessary. The appeal petition of husband may kindly be pending. Can you allow? There is a quarrel between the husband and wife. Married life is 25 years.
On one hand, there is a version of hanging, and on the other side, there is head injury on the neck. So it is maybe concerted rule also. Just wait for.
And delay of 5 days, your lordship, there is no any explanation of such delay, your lordship, FIR.
Initially, they may be thinking it was suicide.
Hello?
Initially, they may be thinking it was suicide, so they had refrained. Subsequently, perhaps.
Some of the witnesses even said, my lord,
Hmm.
my lord, petitioner number 2 is not tall enough, my lord, cut the rope of the victim. Was it?
Attempted to save your lordship, at least mother-in-law.
Okay, let's have it in a early part of next week.
19,
Monday.
19, my lord.
19.
19th.
Right. CD is received, but PM report not received. List again on 19. PM report to be submitted positively by that date. Same order,
It may kindly be written here.
CDP retained till.
My lord.
Obliged.
Is there you was call for?
Yes, there is.
What happened, lordship, there, I between husband and wife, lordship, those he have suppressed that he is not the husband. It is just second marriage. And we are behind the bar for last 47 days. Then the file lordship will find on page 11 is a typed out.
Their husband, wife.
Not husband and wife. She is a widower, my lord.
No,
This
lordship.
accused person, my lord, he comes to her house, my lord, and he used to, my lord, harass her mentally and physically.
Lordship will kindly see page 27. On the same day when FIR was lost, call was there from the police station. I immediately went there, lordship. And thereafter, I was arrested. The FIR was registered and I was page 27, lordship. He is a widow, lordship, but this is a second marriage. Page 20. The before Kaji, lordship is not still. And 20 is the affidavit, first year change.
Her statement, my lord, she has not paid. Accused is her.
Second, Lordship, the actual fact is that she is interested now in another person, Lordship, that is the quarrel is in between.
Marriage certificate is there.
This is Kaji marriage, not.
But this is not the part of the case there.
That has been suppressed, Lordship, not, he neither mentioned about that in the.
What is the, this is nowadays,
Lordship.
nowadays this is a registration in Qazi is available.
According to Muslim Lordship, happens.
How many days?
47 days. All are 60 days.
All Third Learned Council, but application. Paragraph 2. It is submitted on behalf of the petitioner that the informant was a widower whom the petitioner married under Muslim law for the Qazi. And then a certificate issued by the Al Assam Imam Council has also been annexed to the instant application. The petitioner was arrested on
Arrested on Lordship 26/9. It's forwarded on 26/9.
on 25/9/5 after forwarded on 26/25. Thereby he has spent around 47 days. 47 days in custody. Having regard to the nature of the allegation, further detention in custody. Sorry, accordingly, therefore, much he shall cooperate with them. He shall not try to threaten or witness.
Much obliged, Your Lord.
Case that is not received.
I am behind the bar last 44 days, my lord. In a similarly situated case, your lordship has granted bail, my lord. And I take your lordship the FIR, my lord. Virtually all allegations are against Monish Das. Page 16.
Similar means same FIR.
Yes, same affair, my lord. Your lordship has granted already bail. My Honorable High Court has granted 2 person and 1 by session court. My lord. Your lordship has already reflected in the last order.
Here, your name is? In
My name
case-
is, my lord, Deep Roy.
First term. further. 6, 7.
For the forwarding report, my lord, there are materials against it.
What is his role? As per forwarding report.
Page number 20, my lord.
Up to 4 days, my lord, they have not been able to produce the CD. And there was inhuman torture. Human Rights has taken up a case against the IO. Now they are pressurizing me to withdraw the case. I have also annexed the order passed by the learned judicial magistrate CJM, my lord. Page 22 is the complaint before the Human Rights Commission, my lord. Human Rights Commission has taken the cognizance of the matter. How inhumanly tortured this person.
Same material against all the others also.
Yes, sir. Same mail.
Forwarding report.
My objection may be recorded, my
Against Harsh Sharma also, Hima, all have been granted bail.
lord. There is case that is not available to them, my lord, so I have to rely on forwarding report.
We are not producing it. IO is not producing intentionally.
Is there he was received once earlier?
In this case, my lord, it is not received, my lord. Initially, it was fixed on 24/10, my lord. After, my lord, on 4/11, it was.
Finally, kindly peruse page 31. Order passed by the learned CJM, my lord.
Page?
Page 31, my lord.
Torture.
Yes. Relevant portion is 32, my lord. It alleged that the deprived was physically and mentally tortured by police personnel. Such act of petitioner argues constitute offence under section 330 and 331 of the Bharatiya Nyaya and Sanhita 223 and violate the Supreme Court directions of D.K. Basu versus State of West Bengal and other similar judgments on the custodial violence. The petitioner further alleges extortion of the coercion by certain police officers to including the threatening phone call demanding 1 lakh rupees and a plot of land for his own son's release. It is claimed that the officers misused the accused's mobile phone to make this call, amounting to criminal misconduct, extortion, and corruption under Section 308 of the Bharatiya Nyaya Sanhita 223 and Section 16 of the Prevention of Corruption Act 1988. Additionally, the petitioner states that no medical examination has been conducted to assess his son's condition despite the alleged custodial torture. He therefore seeks judicial intervention in the independent inquiry. In view of the petitioner's prayer and the serious allegations raised regarding the alleged custodial torture and physical assault of the accused Deep Roy, this court finds it necessary to ascertain the present physical and medical condition through the official and impartial medical examination. The court therefore directs the jail superintendent conduct to submit a detailed medical report of the accused before 13/10/25. The purpose of the direction is thus to ensure the transparency
and to verify whether the accused has sustained any injuries during his custody as alleged by the petitioner. The medical report should clearly specify the nature, extent, and age of these injuries, distinguishing between fresh and healed wounds, and must include both physical and psychological assessment, and where necessary, such a report will serve the object record and the accused physical state. In this court, further direct the jail superintendent to ensure the accused deploys receives all necessary medical treatment care while in custody. Meanwhile, Human Rights Commission already has registered a case as sir notice, and inquiry has been done by the higher officer of this matter.
Now, for that reason, he was remanded to judicial custody.
Yes. But your lordship can assess that how the police has gone to what extent.
From this full PS, my lord, so we can
But
It's a
44
short
days
debt.
behind the bar, my lord, I am sure that they will implicate me in other cases also.
Very good, then wait. Instead of coming out and going back,
No, my lord, because they are pressurizing to withdraw the complaint. That is that now they are not sending this CD. They know the CD. If we send him,
okay, if dispute, we can have it on Friday.
Yes, my lord, Friday.
Have it on Friday then.
Friday.
This is the first time only.
yes,
First. I thought second or time. CDS call for has not been received. IO is directed to produce the CD deposit. The next date fixed. List again on Friday.
Biplab.
है नहीं Fail hearing that. Fail hearing that. Did you receive?
Item
23.
23, my lord, case diary not received, my lord. My lord, I'm sorry, my lord, is charge sheet submitted, my lord, in this case.
What do you want to do?
We will also get a charge sheet copy, certified copy. The matter may be fixed on Friday. By the time we'll place the charge sheet with your lords. So I'm a student, again. charge
This
sheet
is submitted by learned additional PP that CS has been submitted.
By case number 116/2025, dated 22/10/2020. 116/2020.
We'll get a certificate.
Call for the TCR
Yes, ma'am.
along with CD. Scan copy of TCR along with CD. But we'll fix it soon because he says he can get it.
Yes, ma'am.
We'll get a certificate copy. If it is
No,
Friday.
you will produce only, my lord, the charge sheet, my
Charge
lord.
sheet.
Yeah.
But TCR, my lord, everything will come.
Where I am, which section I have in charge, that will be revealed from.
You will not be able to furnish the CD.
I'll not be able to, only the charge sheet portion.
Yes, but
Maybe
all
I'll
this-
fix on Friday.
Friday,
I'm
my
a
lord.
student. I'm a student.
Monday or Tuesday, my lord.
No, no, I'm a student. Therefore, I'll make my endeavor. If I cannot place before your lordship on Friday,
all right, let's fix it on maybe on the basis of charge sheet we can decide.
Lord. on Friday
Friday.
of rice mill.
Yes, there is. 24 allocate 40.
Happy. Page 10 is tough.
You're the driver.
No, Lord. The allegation is against the driver. We are the petitioners here in
They were in the roadside, Your Lordship. We have a grocery shop, and the truck was just beside the roadside near the grocery shop at night. And we approached the truck of getting some sugar bags as they were unloading some bags from the truck. And we had no knowledge that the same were stolen property.
So innocent.
No.
Is that the way to buy sugar?
No, that is the mistake that they have done.
Somebody is
They are
unloading
behind the
and-
bar for 36 days, Your Lordship.
Yes, what is there?
And
The stolen articles are recovered from the possession house of the these petitioners, Alauddin and Gulzar Hussain. Some articles of it, 3 cartons, Dawson International License, full packaging, 118 bags, Tindal Gold, lots of items, articles.
And otherwise, what is their link? They got it.
As per their
purchased it.
statement and going to the case, they Lordship, one driver called their petition number one sons. Called them that I have some materials. You
So
are
they are
buy.
basically receivers of stolen
Receivers of
property.
stolen
isn't it?
property. And they are in 36 days, 35 days in custody now.
So do you oppose or
Yes,
support?
materials are there, but how they connected, other things are there, Lordship, they are yet to be ascertained, but drivers are already funding. They have not arrested yet, Lordship. And that there are 3 sons also, they are yet to be arrested.
Lordship, the sections that are attracted herein are theft and, Your Lordship. That can be expected 3172 is 3 years.
They have bought
And the Ernest guidelines has also not followed. Notice has also. And the sons that are talking, they are the son of number 2, who are wrongly being charged with having some. They are just walking a grocery shop for his father. They are all family members.
One of the son, Khadimul Islam, paid the driver 10 lakhs rupees of amount as per their statement. They have bought the articles and payment of 10 lakhs rupees. 10% Alauddin. Alaluddin.
Already. Guidelines that is.
What about notice? Notice was issued.
It was issued that article. Notice but not the Lordship.
Not issued.
Notice. No, we are in the case, they not here, Lordship.
Heard learned counsel for the petitioner. Senate PP. This is an application and paragraph 3 of the bail petition from 3rd line on 4/10/25. Learned additional PP upon perusal of the CD submits that the present petitioners purchase the goods, stolen goods from the main accused persons who are the driver and handyman of the vehicle, who are said to be absconding. In the meantime, the petitioners have spent 31 days in custody. It also appears that notice under section 35(3) PNSS was not issued to the petitioners before their arrest, which is in violation of the judgment of the Honorable Supreme Court in Ernest Kumar versus State of Bihar, AIR 2014-6756. Learned additional PP submitted that the goods were some of the stolen articles were recovered from the houses of the petitioners, but fairly admitted that no copy of notice under section 35(3) BNSS is available in the case diary. Para having regard to the period of detention, as well as the apparent violation of the provisions of section 35(3) and the directions of the Honorable Supreme Court in the aforesaid case, the prayer for bail is allowed 50,000 on surety each. Provided that petition cooperate investigation shall not try to influence immediate.
Item number 47, Lordship, the AB.
The AB of the same FIR, the son of.
I have serious objection regarding that, Lordship, because driver is yet to be arrested and they have absconding from the plate of incident, Lordship.
We will hear that later. 20. This is item 24.
40.
Seven.
If they record the.
Yes. Yes. What is his involvement?
Lordship, the driver.
Here, there's the son of the.
Driver made the phone call to them, Lordship. There are sons of arrested accused Alaluddin, from which possession the stolen articles were recovered, some of the stolen articles. So their driver yet to be arrested. Lordship. They are absconding from the plate of incident. Lordship. So their custody detention is required, Lordship, at this stage of investigation, Lordship.
If they record.
And they will not say that way. Our learned counsel for the bit. Additional PP, this is. Pre-arrest. Him. Is said by learned additional PP. But is the area that the it is the arrested son of the arrested accused person from whose possession the stolen goods were recovered, was in contact with driver of truck. Therefore, his custodial interrogation very much as the state driver and the man are still responding. Regard to the there was the allegation, the prayer is rejected.
Item 8. Item number 8 plus 5.
Sense করে দিব হ্যাঁ
Eight number item.
Item 45, my lord, my authentic information with number and date. Charge sheet. So, my
what do you
lord,
want to do?
my lord, here in this case, my lord, our case is that, my lord, it's a case of, my lord, my lord, but it's wrongly recorded commercial quantity. As per my lord, order of the learned trial court, my lord, page 24, my lord. It held that, my lord, 10 bottles weight would not be, my lord, more than only 33 grams. Therefore, my lord, it was rejected. Page 24.
When were you arrested?
Arrested, my lord, now, my lord, 72 days, my lord. 28, 2020. As per order, my lord, page 24, it is held that, my
Is the list is
As per their submission, charge sheet submitted, but we have not received any instruction regarding charge
yes,
sheet.
charge sheet number is, my lord, 75 of 2025, dated 18/10/2020.
under section?
Under section same, my lord,
Commercial quantity.
21.
And according to you, from where from do you say it's not commercial quantity?
My lord, it is, my lord, it is, well, page 25, 24, lordship, kindly have a look. Learned court held that, my lord, it 1 kg, my lord, commercial, but here, my lord, 30 gram, assuming that, my lord, this 10 bottle weight not be, my lord, more than 30 grams. It is lightweight plastic bottle, therefore 1 kg is there, my lord, 33 gram would not be weight, my lord, for 10 plastic. Then otherwise, my lord,
We cannot decide like this because this is borderline thing. You have to see whether they have been weighed separately or what else has been done.
as per order of the, my lord, trial, I
No, all right, let's call for the scan copy then.
Scan copy of the
kindly only short date me.
Scan copy. Along with this.
Hailakandi. Twenty 25.
Kindly 20, my lord, kindly. Just try, my lord. If you come, my lord, you lord, the hail, my
All right.
keep look.
20.
20 level. Keep level.
The case, you know,
Case, my lord, CD was called for, man. Today is the 5th day.
Receive.
It is not received. Petitioner is on interim, lord. We have
Very
not followed the case diary.
The
This is the
interim
fifth
order
day,
passed earlier. The next date. Next date.
Bye.
Interim continue.
Yes.
May I please, lord? 3 months. First go. Not effective.
Same one.
Is an interim, lord.
Interim continue.
26. Is an interim, no? 28/11, lord. It may be gone. Still gone. Submit. Charge sheet submitted, lord.
So what do you want?
Interim also नहीं है,
I'm not in. Not in interim. Lord. Kashi submitted.
approach before trial court.
Your type.
Maybe dispose of.
Third learned council. Additional will be submitted such. Submitted by CS number. Learned counsel for the petition submitted. Shall appear before the learned trial court and apply for. Accordingly, petition. The observation petition. Petition for bill being filed. Same. Yes. Here we get a 15 days. Till then, there is no hearing.
Yes, number 453/25, dated 29/9/25. 453/25,
dated 29/9/25.
Go back.
Administrative bail was granted interim, but has obtained a copy of the charge sheet has submitted in a copy. Charge sheet is submitted before. Case of conceptual with my lord. In fact, in the charge sheet also, IO has given a finding that we're having this as a copy. If otherwise appeared, that is also detected in. Third page, my last three. The
Last para.
last three paragraphs, matlab, from bottom. There's a reference to some video, my lord. The IO said that no such video was found. Second last paragraph, the IO has said that they were having visit. Second page detected that have appeared. Second page, my lord. 17, my 18, my
Part is the about the consensual nature of the relation, but other part is the circulation of the video.
Yet, my lord, the IO has said that no such video was found. My lord, no other offences have also been. There was an interim.
You are an interim, let us have this. PCR. Found. This prosecution will also not be comfortable. Submitted by law for the yes, even submit. Here. Call for that.
Twenty. 28/11.
Interim order may be accepted.
First. Till hearing kita patapat.
29 lordship interim was there, case they not received.
Order.
28/11.
Same date, ma'am. Some deeply.
No. CD not received. Please again of.
Some deeply.
Same prayer petitioner either interim lordship, we have not received the case diary.
Same order. 31. Same order.
28/11.
He received lordship.
Time of hearing appeared before the
Appeared lordship. Statement recorded.
statement recorded.
He received 20,000 from his bank account.
He's got it back. He got it back. Returned.
No.
Of another person.
He received it, the account of another. The account,
If it is from for another person, how can you say he received it?
lordship, from the statement,
He says,
183 statement is there, lordship.
what is his explanation? No explanation. Why he received 20,000? If we allow anticipatory bail, he'll not return the money. Is it not?
Kindly peruse the FIR, Lord. The allegation is that lordship in the name of giving Padma Bhushan award, Lord. Conferred by the government of India, Lord.
But he has to take the proposal to government of India.
Lordship. Appeared, Lord, providing obtained.
Dated 26/5. First, second, third, fourth. Para. Perusal of CD permitted the person to enter in protection. Petition appeared before the IO. Statement so appears that the amount of rupees 20,000 deposited the account of some other person by the on behalf of present petition. The petition already been interrogated by the IO, having to the care of investigation. First, detention. Till interrogation of the petition for this of interim period will dated 9/5 hereby made absolute upon the same.
Right, your lord. Right, your.
Kindly this may be taken from
All right, Friday.
Did you receive?
CD receipt be retained?
Oblast.
Yes. Follow up on 9. One appears list again on Friday. 9.
Regarding item number 46, kindly this matter may be taken item.
Which item?
Yes, item. 46.
Yes, we've already given it on Friday.
Yes, I'm obliged.
Yes,
Lordship,
Mr. Sharma, how long will you take?
So I don't want to bother much. Lordship is in the affair. The allegation in the affair is plain and simple. It's as regards to the false document of the that particular birth certificate, Lordship. Now, so far as the whether the Mani Subba is the wife or not, that is not it, or father of the child is not, that is not in dispute. The dispute is who is the mother and whether that birth certificate is genuine or not. Now, Lordship, that has been given, reply has been given by the joint director. That is it's appeared in the name of some different person. So this is a matter of investigation. That can go came only like Lordship has to go for trial to judge who was the conspirator or who get derived benefit from that. Now, Lordship, I am to rely on Lordship to decision, Lordship, whether at this stage it's the court has to give a microscopic examination of the whole issue or not. Court cannot go into the details of minutely all the what has been stated in the FIR or not. And so far as that counterblast is concerned, Lordship, that was taken, that is not a ground taken in the criminal petition, Lordship. Lordship, I'm relying in this 1999 3 SCC page 259. The relevant paragraph is paragraph 12, Lordship. May I read paragraph 12?
Yes.
The High Court seems to have adopted a strictly hyper-technical approach and sieved the complaint through a colander of finest gauges for testing the ingredient under section 415 IPC. Such an endeavor may be justified during trial, but certainly not during the stage of investigation. At any rate, it is too premature a stage for the High Court to step in and stall the investigation by declaring that it is a so-and-so, so-and-so, so-and-so. So, Lordship, this is not the stage to give a microscopic view or examination of the whole issue. And the next case, Lordship, that's Niharika case, Lordship, I'll be relying. Lordship is aware of that. I don't want to bother, Lordship. Paragraph 33, all this condition which has been laid down. This is not a fit case which come under the, which, Lordship, this Niharika judgment. These are the guideline, Lordship, which has to be followed. Paragraph 33. Lordship is aware of that. I don't want to bother your Lordship with. So all the ingredients that has to be satisfied only then, Lordship. And that also that is the word of caution, Lordship. And this has been followed in by the ED case, Lordship, subsequently, Lordship. That ED case is, Lordship, is very recent, 2024 AIR, page 1161. This has been, Niharika case has been relied in the ED case. The relevant paragraph are 21, 20, 21, 22, 24, and 25.
And paragraph 24 strictly said in the ED judgment, Lordship, the guideline of Niharik has to be strictly followed. So that's all, Lordship. This is not a case which has to be identified at this incipient stage.
All right, CAV.
Obliged.
Lagi kung kita sa mati. Provide. Enough.
May I please, Lord? Matter last 565 was issued on the private respondent as well also called for. Till date, neither the private respondent appeared nor the courts. Where pray that the courts may call for permit fresh steps of private respondent.
Notice on private respondents not yet served. Petitioner to take fresh steps within 3 days. I registered posted list again for 4 weeks.
Courts of call for
TCR not received. Issue reminder for TCR.
what's up?
Yes.
Product clerical error in order dated 11 to that is for 11/6.
But for correction,
Yes, my lord. My lord, informant M wrongly type my lord Novit and other FIR laws on dated 18/8 to 25.
all right, we'll
in
pass
respect
out.
of
December. What is this for?
My lord, I have filed this passing of order dated my lord 24/24, whereby the learned magistrate framed charges under section 420 of I. Imping order is page 3.
Today there is no time to decide the case anyway.
My lord,
that may be fixed.
Prayer of learned counsel for the parties is the matter on to ensure interim or past failure to continue till the next date of list.
Obliged.
28. Obliged.
Yet, so there is the interlocutory application for consideration.
Okay.
Lordship,
When do you want?
IA is for suspension of sentence and release of the petitioner on bail.
No
That's
time
all.
today.
Lordship,
No time today.
10 years,
What is the sentence?
10 years, Lordship. Already he has
10 years.
5 years,
Half is complete.
almost 3 months. Well, lesser than
Yes, Borua, what do you say?
that will take time, Lordship. Only Lordship. It IA, Lordship. IA for hearing,
Hearing of the IA.
Lordship.
Next Tuesday.
Obliged. Next.
Hmm?
Hearing date. Next.
All right. The prayer of learned counsel for the parties list the matter on the date.
I'm on behalf of respondent number 2.
Second, Lordship, can it be in last week of November, Lordship? As here I've been-
All right, give a date, give your date. Don't say last week, first week, give it.
Lordship, published.
If any date.
The prayer of learned counsel for the party is the matter on with the date.
Published.
It has been come, my lord.
LCR has been
Finally,
received,
finally
is the
there.
matter for hearing on.
Last November last.
Just,
Yes, call up next.
24.
Oblige me.
On 20th.
All right.
0.
Prayer of to time.
Maybe first week of December.
All right. Prayer of learned counsel for the party is the first week of 41.
May you please, your lordship, I am in jail custody for last 10 months, your lordship, in a sentence passed by learned and just lucky for your lordship.
Okay, tell her when you want.
I need bail, suspension sentence, your lordship.
Yes.
For the accused Posale. Yes, my lord.
Okay. So we can't have it today because we are rising early. Only
Lordship,
5 minutes left.
Lordship, give a 3rd of December because other matters fixed on. I'm coming for 48, not like
3rd of December.
3rd of December.
All right. $49 to have.
Public.
I am on behalf of the private respondent.
None appears.
Matter is about to be.
None appears for the petition. Learned counsel. Private. Is the matter again? Just give a date.
18th of December.
All right.